universities that are offering LLB courses. In our time, it was only the University of Ghana. And then from there, you come to the law school. So the number was few. Now, it has been expanded without corresponding, maybe, infrastructure to take care of all those students. So I believe that is why the numbers have swelled. Now, proposing a solution, offering a solution to the problem, I would think that those who have already passed their LLB and are waiting to enter the law school must be given what we call an immunity. Immunity in the sense that they could be grouped and then given maybe depending upon how the General Legal Council are going to do it. I think they can put a system in place where the students can be, grouped and then they are given the chance to do the courses at the law school. Now we have Kumasi Campus Law School. I think UPSA is also doing the same. So if they are given immunity and all of them are offered the opportunity to go to the law school, because invariably everybody who has entered the law faculty to do LLB wants to become a lawyer in the long run. And I do not think it would be fair for us to impede the progress of the students who want to come to the law school. So the system must be looked at again holistically. The General Legal Council, together with maybe the director of the School of Law, they need to sit down and fashion out. And of course, there must be, also a debate. The academia must also be involved because they also have a role to play. Somebody has suggested that the courses being run at the law school must be taken there to the law faculties. That is another way of maybe solving the problem. But the question also arises that the courses taught at the law faculties, they give the students the basic foundation of the law, theoretical. What is taught at the law school are professional courses. So most of the courses there are practical. Therefore, if the law faculties have the capacity to run those courses with the oversight responsibility of the General Legal Council, ensuring that, because here too we are talking about quality assurance must be applied. So the General Legal Council must also get involved in some of these matters and find a solution to the problem. Thank you.
Thank you, Chair. My second question. Judges are seen not to have a social life because of the kind of work you do, pressure on you to read cases and run around. How do you balance social life with your career? Thank you.
Thank you. The life of a judge is something which unless you have come into a fold, you will, because the steps that you take wherever you go and the things that you do, you are in the public eye. So when we are also talking about trust in the system, you, the judge, you must behave yourself such that people will have confidence in the courts that they are coming for justice. It's not only that the judge, justice must be served, but they must be seen that justice is being done. So, for example, if I'm a judge and I move my car and go around, taking on board all manner of people as my friends, it gives room for suspicion and the rest of it. So sometimes you have to isolate yourself. Me, for example, I pick and choose my friends. And if I haven't traveled out of town, Sunday, I will make sure that I go to church. So my work and church. I believe yesterday, the last, nominee said something which we were all amazed that because of his work, his marriage has to suffer. That is the kind of we had to show. And the point is that even if you see a friend, a lawyer, you can't even go and shake hands with him because people will say that he is the friend to the lawyer. So that is the situation we find ourselves. But you see, that is the job we have sworn to do. So we will manage it. Thank you.
Thank you, Mr. Chair. No further questions. Congratulations once again. All the best.
Thank you very much. Then I'll give the floor to Honorable Obama.
Thank you very much. Congratulations, my lord.
Thank you.
Chairman, full disclosure, my lord has been a very good friend of mine for many years. And I'm happy to see you go up as a Justice of the Supreme Court. Even if you are going to spend a year there, we know what you are going to send up there. And I wish you well.
Thank you.
My lord, first time I appeared before you was about 14 years ago.
Oh, that's so?
I remember Republic versus Oseji, Antonia Kutose, Jambafo, also Professor Jambafo. And the former Attorney General was for Oseji. Brilliant submission of no case, which you upheld. A 90-page submission of no case, which you upheld. And Oseji got out of the woods. I've read recently some decisions of yours, the Mewu matter, the Atufosi matter, that I know you to be a very bold judge, regardless of who is before you.
Thank you.
And that is commendable.
Thank you for the observation.
That's very commendable. What gives you that weight and motivation? Because the kind of cases that I've read you handle and taking those bold decisions are very political in nature. The stakes were very high. I would have wished my colleague Bafo to have been around, since he said most of your cases are overturned on appeal at the Supreme Court. Some of these cases that you also overturned came from the High Court. So I would want to hear your views on some of them. The Amewu matter, the Oseji, Jambafo, Atufosin and Co. So those are matters that you've determined already, so you can give us an overview. Thank you.
Thank you, Chair. In the Amewu case, is it what? Amewu?
Amewu, John Peter Amewu.
John Peter Amewu. That case is still sub judice. What came before us was for an application, interlocutory, for an application for interlocutory injunction. So the case itself is pending for hearing. The appeal itself is pending for hearing. So it will be unethical for me to say something about it. Thank you. In the case of Osia J,
do you still remember the facts? Talking about some rice importation from India.
From India, I do to some extent, but it's, as you rightly said, it's a long time ago. So what I would say is that in that particular case, or generally, my position has always been that as soon as I hand over my judgment, I don't think about them again. Because if you are dissatisfied with it, you have the opportunity to go up. So it will be very difficult on my part to discuss it now. Unless, so please, let's
Malad, I'll step it down and
Thank you.
and ask you if you still have some good friends at the bar, because when you're at the financial court one, anytime a case is brought to you and the lawyers discuss, they say, you're going to the Justice Bright Mensah's court. On 1-3. Even if it's dismissing application, you even put a smile on his face. You just ask you to go out. Lord, all I want to entreat you and beg of you is to keep being yourself.
Thank you.
Keep being a firm judge.
Thank you.
And I wish you the very best. Thank you.
But you see, Chairman, please, my court is very friendly court. Very, very friendly. If sometimes, thank you for the comments.
Yes, I'll give the floor to Honorable Haji Aladi Ayamba.
Thank you, Chairman. Congratulations, my brother.
Thank you.
Looking at your CV and where you are coming from, you deserve it. You've worked so hard, rising through those ranks.
Thank you.
I think this is something that needs to be discussed with those up and coming. Some people think you must just get up and get to the topmost level, but here you are. Looking at where you came from and the issues that we have at hand, especially on the ground, when you go to our villages, for that matter, our districts, what is your suggestion about facts that we don't have, for lack of a better word, let me say, lawyers around, where maybe in Pusiga, you have a case, you even need somebody, you may have to be calling Accra. We don't have the judges. Sometimes one judge is handling so many districts, or there may be only 2 judges in one region, and they continue shuttling, going up and down. What is your suggestion? What will you bring up to encourage whether those who are already trained professionals, so that they will take up places that are deprived, or judges to accept postings to such places?
Thank you, Chair. I think the solution to the problem is that the conditions of service, particularly at the lower court, must be attractive to lawyers to start from the lowest bench. Quite often, lawyers who want to join the bench will want to join it from the superior court. But when we talk about the work of the courts, it's those down there who normally do the bulk of the court. Indeed, when we are talking about access to justice and quality justice for that matter, it starts from down there. So therefore, to attract lawyers to start from the lower ebb of the ladder, then it means that the condition of service must be very, very attractive. I myself, when I started, I was also started with going to other courts. It was because there were no lawyers available to be engaged. Not that they are not available, but they didn't find our conditions of service attractive to come to start from the lower. So the solution to the problem is that the condition of service of the judges, particularly at the lower bench, must be attractive for the lawyers to start from there. I believe that if the conditions of service are attractive, many lawyers will join the bench. Thank you.
Chairman, my second question. Cases take so long in in courts, whether rural, urban, whatsoever. Some even eventually they die and the cases are not ended. They are not determined. Thank you for giving me the correct word. Are not determined. What is your suggestion to ensure that at least we make sure these cases are determined very fast so that we don't have so much at hand?
Thank you, Chair. There are so many factors that come into play when cases delay in court. I will not go into that because I'm being called upon to offer an advice or suggestion as to how they may be addressed. The first is that the judicial service must get their system digitalized, because now the modern trends are that if we were to digitalize our systems, cases filed will be filed electronically. When they are filed electronically, the belief that we will have to effect service will also do it. The proof of service, if it is served, you will issue proof of service and then it will be uploaded into the system. So we will not get a situation where a bailiff, though has served a process, will not prove service. Once proof of service is not on the docket, though the process has been served, the judge cannot go on with the case, and that will mean that the case must suffer an adjournment. When we also talk about e-justice system, we are also talking about virtual court. In other jurisdictions, even in Africa here, Tanzania and Kenya have invested so much in the judicial system, such that once the cases are filed electronically and the solution of cases are generated electronically, so the Chief Justice will not even have the power or has no control over who should sit on a particular case or the other. Which means that as soon as the processes are served and everything is in place, a judge who has traveled to his hometown, maybe I might have traveled to Amasma, and if a case is put before me, I will not have an excuse to say that I'm not in Accra, so I can't do the case. It's virtual court, and sometimes you can also use Zoom to do those cases. If we were able to do that, I think it will be a leap forward, so that cases will be tried as expeditiously as possible. But if we feel that we must remain where we are, we won't get far. So that is the solution I would prefer to the problem on hand. Thank you.
Chairman, what I'm about to ask might not necessarily be in the Constitution, but it's an act under the Criminal and Other Offences Act. There is this statement I've read in it that states that a child can have sex at 16, but can only marry at age 18. It has been baffling me because why do you think that someone has the right to have sex at 16, cannot marry at 16, but should wait until 18 because we say it's a law? Now, sex comes with so many things because you carry responsibilities when you go to have sex, whether at 16 or at 100. You may become pregnant, you may, a whole lot of things. What should we do? Should we bridge the gap between the 16 and 18 and make it that at least 18 is more acceptable, that the right for anybody to have sex is at 18, and when there is anything, even if you get impregnated, you could marry the one that you are interested in, or we should reduce it to 16 so that we don't even have that gap.
Thank you. I think the intent of the law, which puts the marriageable age to 18, was thinking that by 18 years, the girl will be a mature person to be able to know her responsibilities so far as marriage is concerned. Now, why should a girl have sex at 16 and not be permitted to be married? There's more of a moral question, sort of, because look, 16 years, what does the girl know? The girl does not know anything, but if she's 18 and the Constitution even makes describe an adult person as 18 years. So if you are 18, the presumption is that you have seen life a little to be able to be independent or think for yourself when you are married. But if you are 16 years and they are taking you into marriage, I think it's quite. See, at 16, the girl must be in school. You should not go and follow a 45-year-old man. Thank you.
Chairman, the response I was asking, with that, your explanation, I'm quite satisfied. But I need to know whether we should then we should amend it.
Amend it to
18 years for both sex and marriage, or it should remain as it is.
To amend it to
18 years. To 18 years.
Oh, then that the girl can have sex.
Have sex at 16.
Hey,
My lord, I think if that is done, the defilement cases will be a lot.
I see. But the point is that will these girls wait to 18? That is the question we must also settle ourselves with. If he remains in chastity to 18, well and good. But you as a parent, you will be sleeping and your daughter will be somewhere else, which you have no idea about. How can you control her? So please, let the law remain what it is, at least for now. Thank you.
Thank you very much.
Thank you, Chairman. Thank you.
Yes, Alhaji Omar, you have the floor.
Thank you, Chairman. My Lord, Philip Bright, congratulations.
Thank you.
My question is bordering on judicial or policy litmus test.
Judicial
or policy litmus test.
I didn't hear you well.
Okay. What is your stand on gun ownership?
Gun ownership. Gun. In fact, I think our laws are said that if you want to own a gun, first and foremost, you need to register it. So if your gun is unregistered, then you have already violated the law. And I'm sure that this is to prevent people from, using the gun not intended for the purpose for which the gun was acquired. So my position is that if you want to own a gun, first you must be an adult, and then you must also register it as the law requires. Thank you.
Thank you. The second question is, what is your view on the doctrine of separation of powers?
Separation of powers, it's somebody will say it's a political doctrine where the three arms of government are given their specific rules to play. And that's overlap. It's overlap in the sense that you can't say that because you are a judiciary, you will not have anything to do with the executive. And that the executive will also not have anything to do with the legislature. I thought the core idea of separation of powers is to ensure that the three arms of government, there will be checks and balances. So no one arm will be controlling the others. It's the duty of you, honorable members of this house, to ensure that when the executive is going astray from what, after all, that is what good governance is all about. Thank you.
Decisions to stop it. Is that not usurping of or interference in the separation of powers?
Thank you, Chairman. The law, as I understand it, is that if what the parliament sought to do has to do with interpretation of the Constitution, then the judiciary is seized with that jurisdiction to go into the matter. It's not as if the judiciary is becoming a schoolmaster. Of course, in any event, Parliament, you are masters of your own, what do you even say it? Masters of your own rules. So if the rules are fashioned in consonance with the law, and for that matter, the Constitution, I do not think the Supreme Court will jump on to your head and say that, don't do this, don't do that. So, I would say that that case in question that you are talking about, if it bordered on constitutionality and interpretation of some provisions of the Constitution, then the Supreme Court has the right to intervene. Thank you.
I wish you all. Thank you so much.
I will then proceed to give the floor to Honorable Jerry Shaib.
Thank you very much, Honorable Chair. Let me take this opportunity to welcome the Honorable nominee and Nana Doctor and all the. I have a parcel of land in that area, so by extension, I'm a sub-chief.
Is that part of assets that you have declared?
Mr. Chair, I was given the land last night. Thank you very much. Nana Justice, congratulations and you are welcome.
Thank you. Thank you.
Honorable nominee, you've been a registrar of the court, and I believe for a period before getting to the High Court and then the Court of Appeal. And therefore, you are versed with a lot of knowledge on judicial matters. Respectfully, would you recommend any judicial reforms to this committee?
Certainly. Thank you. I've already made mention of some reforms that we can put in place to ensure that cases that come for us are tried expeditiously. And I made a point of this e-justice system. I think the rules of court that we also work with needs looking at again. For example, the High Court rules, CI 47. Indeed, we had the previous one, which was promulgated in the 50s. It was only in 2004 that we changed it, and that has become our tool that we work with. Now, there are also inherent difficulties or problems with some rules of our engagement. For example, interlocutory appeals. I'm talking about interlocutory appeals, both in civil and in criminal. Interlocutory appeals, when a decision is made by a trial judge, once the case is still pending, most often the party that is dissatisfied will want to go on appeal. In that case, and if he applies for stay of proceedings, it's certify the hearing of the case. So I want to suggest that yes, they have the right to appeal, but there must time limits within which the appeal must be heard so that it doesn't affect the hearing of the case adversely. Now, coming to the criminal aspect of it. Now, this has become fashionable that if you are doing the case as a judge, when you cough, a party want to go up. When you sneeze, and sometimes they go even as far as to the Supreme Court. Meanwhile, then the case will still be pending. So I strongly advocate that the right of parties filing interlocutory appeals in criminal cases where the prosecution has not even ended its case must be stopped. And we can only do that through the amendment of the law, that is Act, talking specifically about Act 30. Now, another area which also needs reforms is our jury system. We inherited this system from our colonial masters, Britain, where they started this system. As I speak, India, some Commonwealth countries like India, Singapore, and South Africa, they have abolished the system. Why? Because it's not functional. Now, our experience in our jurisdiction has shown that that system has outlived its usefulness. So I would advocate that instead of the jury system, there must be assessors. Now, if you permit me, I will give one example. When I was in the High Court, I did assizes. That was before my transfer to Expediting in 2015. I did a case where I had summed up the evidence to the jury, and as much as possible, I did that everybody in the courtroom, or maybe those in the courtroom who understood what we were saying, anticipated that the jurors were going to, bring a verdict of guilty. They came out and said that the accused persons were not guilty. And you see, the law is also that they are the judges of fact. So their verdict is even binding on you, the judge. You may disagree, but you cannot open your mouth. You have to work with it. And there was a doctor who has been subpoenaed. I've come from Ankafor Psychiatric Hospital to give evidence in the case. The doctor was in the court when I was delivering my seminar. The man was so disappointed that he said that if that is what the jurors here are doing, then I will never come back again. He didn't come. So the case will have to be, I left it because I was then on transfer to Sekedi. So we can give examples, but because of constraints of time, I will not do that. But I'm saying that in its place, we should establish what we call assessors. In assessors, the judges who will try the case will be three, and there will be lawyers. I mean, there will be lawyers who have become judges. They will sit on the case. And we have it on our statute books when judges try treason and high treason offenses. It's assessors. We don't do it. Jury. Our jury system here is porous. Some of them have become professional jurors. So that is one area which I will advocate. Thank you.
Thank you very much. My Lord, I asked this question yesterday. I think it was Sir Dennis, my Lord Sir Dennis, that responded. But just opposing that with his response and yours, I'm looking at the issue of, for instance, the criminal interlocutory appeal that maybe a suspect or a witness believes that whatever ruling you made or whatever consideration you made would affect him or her. And if it is not corrected at the point that it has to be corrected, you would end up giving a judgment that would convict him and others. You don't think that the issue of time is key? That's what you said. But are you in the position to propose the time frame within which such appeals should be considered? Which I think is very, very crucial. Because if, for instance, I'm able to know that I can get an appeal for an interlocutory matter so that the court can proceed to deal with a substantive matter, would you consider giving us an idea of what time that appeal should be considered?
In my earlier submissions, I did make a point that if a party is aggrieved with a decision by a court, because the case has not traveled to its end and it is still ongoing, then that will be an interrogatory decision done by the court. Now, it's trite that when a case has not come to an end, or when in criminal matters, when the prosecution has not closed its case, the judge has no power to convict. Therefore, if you want to appeal against an interrogatory decision, you will not be, as it were, at that stage, the court cannot convict you and sentence you. So earlier on, I did propose that right for parties, it could be the prosecution or it could be the defense, to file interrogatory appeals while the case is pending, must be reserved to the end of the case or at the end of the course of the prosecution's case. That one is allowable, I think, that so that the hearing of the substantive matter doesn't suffer. Now, if it comes to the time that we should allocate for filing of the appeal and hearing it, I will propose that when the appeal is filed, interrogatory appeal is filed, the registrar should be able to compile the appeal within 14 days. Because invariably, it's not every document that has been tendered in the proceedings that will have to be embodied in the record of appeal. It's only if it's an application, yes, it will take the processes that were filed in connection with that application, and then the decision of the court itself, that will be the relevant records that must be sent to the Court of Appeal. And when it is sent to the Court of Appeal, then the rules of court must also amend the rules to say that if it's an interlocutory appeal and it's of urgency, it's urgent, then that appeal must be heard within at most, is it at least or at most 30 days, so that it will not badly affect the hearing of the substantive case at the trial court. So that is my proposal.
Very well, thank you very much, my lord. My lord, were you once a magistrate, and would you pray that career magistracy be abolished?
Not at all. I would rather advocate that the system must be, must be strengthened, for want of better word. Because you see, this career magistrate came about as a result of when the Courts Act was amended. First we were sitting as tribunals with, panel members. I think in 2001 or so, when President Kufuor came into office, the parliament sought to reverse the system back to its former. So now, then we had magistrate. Because of the vacuum that was created, most of there were so many vacancies. So that was why at that time it became necessary for the then Chief Justice to fashion out this career magistrate system. And it is not, Ghana is not the only place that we have, applied this system. When you go to Nigeria and Zimbabwe, they have that system. And there's a career part where you can start as a career magistrate, and you, by dint of hard work, integrity, and your competence, you can rise to become chief magistrate, which is an enormous grace of a high court judge. Now, here, there's some difficulty with our system. Currently, because the service felt that we must encourage lawyers to come to occupy those positions. And as I said earlier on, the lawyers, when they want to join the service, want to start from the superior courts. So, as at now, there are about 70 plus more career magistrates still in the system, and those ones are in the hinterlands, and they do the same work as that of professional lawyers who have become magistrates. So instead of scrapping it, it should be strengthened. They must be given the opportunity to also go to the law school, educate themselves, because when they come back, they also come and join the service. There is a second judge in Kumasi, started as a career magistrate. He had the opportunity to go to school, and now he's a second judge. So instead of scrapping it, because if you scrap it, and there are vacancies in the hinterlands, as Madam was saying, who will go there to, do this career magistrates who have been going push to the hinterlands to handle the costs there. And it's important that we should, encourage them to also come up with their competence. Thank you.
Well, that will be, I have my final question. And sitting in as a judge, Lord, what would be your role in curbing the menace of Galamsey? What suggestions would you put forth? And how are you going to deal with issues that come before you, especially on Galamsey?
First and foremost, we have this minerals and mining laws. And the offenses that the law creates are deterrent enough to punish people who are involved in Galamsey. What is left is the implementation, the effective implementation of the law. So I think there should be a collaboration between the service and then the police or the enforcing authorities. After all, we are fighting a common cause. If we allow this to go on, and in the next 5 or 10 years, we are importing water because all our water bodies are destroyed. Can we bear it? One area I also want to maybe hammer or suggest is that there are foreigners who are also engage in this, say, activities, destroying our forests and the rest of it. You know, when they are arrested, especially these Chinese people, when they are arrested and sent to the court, the difficulty is that they don't speak English. Even if they can, you know, they understand English, they will refuse to speak English. And because the judges or the police enforcement agencies also are unable to speak their language, it becomes more and more difficult to get them prosecuted. So I will suggest strongly, or I recommend that the judges who are in the areas where these galamsees are going on, the judges must either be taken to China for further studies in Chinese language, or they should fashion the JTI must be resourced to bring experts to come and train our judges. That also is another way of, because if the person has committed offense and he can't speak, you can't prosecute him. That is as well saying that, oh, let me leave him for him to go away. So that is the recommendation I will make. Thank you.
But my lord, why not get interpreters?
Oh, that is also good. It's another point. But you see, the interpreters themselves, sometimes they are also a problem. So if the judge himself understands the language, language, it will be better served for them to understand what he is doing, what she or he is doing, and for us to, you know, be able to curb the menace of galamsey. Thank you.
Thank you, my lord. But, so, how does it mean that you want to deport a Chinese person involved in galamsey? What would be your stand?
This is a difficult question. Difficult in the sense that the power to deport is the executives. I'm not in the executive. So I cannot, with all due respect, answer this question. Because the discretion is the executives. Thank you.
Thank you very much, my lord. I wish you all the best. Thank you. Thank you, Chair.
Yes, Honorable Koku, okay, taken. You have the floor.
Yeah. Thank you very much, Mr. Chairman. Nominee, my lord.
Yes, sir.
Justice Philip Bright Mensah.
You are right, sir.
From Amosma.
Yes.
My neighbor. Your neighbor from Cape Coast.
I know.
Are you cool?
Yeah.
Going through your CV, just like Abazi, going through your CV as many of us have done here, your CV is an epitome of what will be described as you have gone through the mill.
Thank you.
You have pretty much climbed the stairs through our courts. So obviously from where you will be sitting, God willing, you will have a much comprehensive view of the whole court system. And I have no doubt in my mind that you will do a good job.
Thank you.
For Ghana.
Thank you.
My questions this morning is on how we can improve the inefficiencies within the court system. In Ghana, even though we have district courts, which are supposed to deal expeditiously with matters, but we often hear that the courts are becoming like the circuit and high courts, I'm told.
Circuit and the High Court.
Yes,
The District Court.
the district courts.
I see.
And we're talking about inefficiencies here.
Okay.
Do you think we need small claims courts which can deal with matters involving claims that are, say, less than 10,000 Ghana cedis, and deal with those cases in a day or a week maximum? Thank you.
Thank you, Mr. Chair. Indeed, the service itself has, over time, devised some means or strategies by which such cases. So, with all due respect, you are not the only one who has raised this question. In fact, even in Accra, there used to be small claim courts. The rationale is that somebody who has a small claim must be able to walk to the district court, Graboso, where I also did my work there, so that you will not require the services of a lawyer. You can walk in there, and of course, the district court is a case, the court of summary trial, so you don't have to file too many papers. You go there, if it's about money, as you are saying, the person, the defendant will be served, and when they appear before the court, the magistrate will ask him, look, you owe this man, are you liable or not? If he admits that he is liable, then you enter judgment there and then. So it's a very good suggestion, a good idea, but it will also depend upon our lawmakers here. If you give us money to be able to set up the courts, we will be able to set up this small claim courts that you are talking about. Thank you.
Mr. Chair, thank you very much. Again, my Lord, I'll go to my second question, no follow-up question.
Okay.
But also relates to the same inefficiencies within our courts and how we can improve on that. And this time with technology.
Okay.
You did say earlier on that if we have, electronic systems within a court, we can improve on things. I think the problem goes beyond just the electronics, but
Okay.
the whole data management of the courts. The data collection and the management of it. You realize that maybe the systems are not there, but I think it will be a good idea for the court to start getting people with expertise in technology to help, sort of augment the work that you do. And that the court should be looking at management systems, because the issue is to do with management. The reason why things are quite slow with the courts. So would you think that it would be a good idea to invest? I know you've done a lot of, you started many years ago to do some automation in the courts. Do you think you still need more investment in automating the court? To an extent, it cannot be 100%, but at least to a level that will make processes much faster than having some years, some cases sitting in court for years without any solution. Thank you.
Thank you. Certainly, yes. The government or the executive, for that matter, must make conscious effort to invest in this project. I said that in Kenya and in Tanzania, I'm told that when you want to electronically file your cases, you walk into what we call here communication center to do it. So if we have been able to also invest in the system such that it's across the board, across the length and breadth of the country, and we educate people as to how we should use the system. It will help us a great deal, because it will mean that most cases will be tried as expeditiously as possible. And when we were able to do that, I think the confidence and trust in the judicial system will soar up. So I will still plead that when our budget comes, please try to even top it up for us, so that we use part of the money to invest in this kind of, system to improve on our efficiencies. Thank you.
Follow up, Mr. Chairman. Would it be an encouragement as well if this investment comes in the system for judges and the whole judicial system to equip themselves with modern technology to be able to, again, be up to speed, in addition to perhaps introducing Chinese classes so you can deal with Chinese issues? Thank you. Since they become quite rampant in our system now.
Mr. Chairman, I do agree. I don't have any qualms about it at all. We should improve our system. Everybody, I'm sure this time, most of the judges, if not all of them, they know how to, use their laptop. So it's a very laudable idea, and I thank you for the suggestion.
With this, I just noticed on your CV that you're actually a chief of Amosma and the Nifahene of Asebu traditional area. Now, would you let us know what your stool name or title is, please?
Mr. Chairman, I'm Nanamwa the 8th, or let me say it in Fanti. Nanamwa Otodo Awachi. May Amos Mahim, and may Nifahene or Asebu traditional area. Mama here not see. Okay, the chief professor Menfi, the 7th, he has come all the way from Asebu to come and support me. And the Queen Mother and the other chiefs, they are all here to give me their moral support. Thank you.
Justice, but who's in the bill? Why he's in the bill?
Nanamwa Otodo Awache.
Nanamwa Otodo Awache.
And you.
Please put your hand. Nana, what's in kwa? Mr. Chairman.
My Lord, ni hao. Ni hao ma.
Chinese, hey, that's the first time I'm hearing it. Thank you, Chair.
It's greetings.
Oh, okay.
Yes.
And the meaning is what?
Like, how are you?
Oh, I'm fine.
I'm fine. Ni hao ma.
Me Hauma.
Yes.
Hey, I see. Thank you.
Yes.
I'm sorry.
Honourable members, I'll proceed to give the floor to Honourable Patricia Piaget.
Right. Thank you very much, my Lord. Congratulations.
Thank you.
There's nobody but Mama Pat from Kumasi. Yes. We've been listening to you. Very interesting journey towards the judiciary. And one of the things I'd like to ask is for you to share with us your personal or professional obstacles you faced on your journey to becoming a justice of the court. And how your story might inspire the next generation of legal minds. Thank you.
Thank you. If I understood your question, you were asking how I rose to become a judge or
Yes, and share a story that will inspire the next generation.
Yes, I think first and foremost, if you want to become a judge, you need to make sure that you should be prepared to work hard. That is point number one. You're also talking about your competence and integrity. The work of a judge, you are settling disputes between feuding parties. So as the statement always go, you must not only deliver justice, but you must also be seen to do justice. My journey, I told you I've had a checkered history, but I want to give one example. You know, it is resilience. You must persist. In fact, when I did I read the diploma in public administration, and I had the opportunity to go to school again to read law. I had then been bonded over to serve the judicial service for 4 years. When I went back to secondary, the following year, I had the opportunity to go to the university. And there were all kinds of obstacles. But it took the intervention of a very good man, the late Justice Archer. He was then the Chief Justice, and I'm always grateful to him that he eventually permitted me to go to school, because I wasn't a family man and I could not have gone to school without study leave with pay. So I worked hard, and my philosophy in life has always been that something worth doing must be done well. In fact, permit me to emphasize that I started my career as a magistrate in Sefi also. I didn't say that because that place is far from Accra, I will do my work as I choose and as I please to. No. Rather, I worked extremely hard, and I had the opportunity to even teach myself the law, because I was always studying the law. I was always reading my law reports. I was already reading my books. And I say this without any shadow of contradiction or whatever, that it was as a review also that the late Chief Justice Aqua identified me because of my hard work. So what I will say is that every magistrate, judge, whatever, you must work hard. Let your work speak for you, and let the promotion be on merit and not of any other consideration. Thank you.
Thank you very much for sharing this with us. My Lord, I want to tease your view on this issue. You know, in Ghana mandates retirement at 70. We have other jurisdictions that looks, especially even in America, that provides life tenure. Would you recommend extending Ghana's retirement age to 75? judges' retirement age to 75, and whether that will require a constitutional amendment. If you personally will support that change. Thank you.
Thank you, Chair. Of our jurisdiction, gently, you need to work very hard, and it is very stressful. So it's not advisable that when you get your retiring age of 70, then you say, I want to go to 75. If you don't take care, the 75 will not even reach, and you will go and join your ancestors. So let the law remain as it is, 70, and then you bow out from the bench. Thank you.
My Lord, what is your view on the Article 66? The two-term for a constitutional term of 2 for each of three Article 66.
Okay, thank you, Chair. 66(1) says that a person elected as president shall, subject to clause 3 of this article, hold office for a term of 4 years, beginning from the date on which he is sworn in as president. Now, clause 3 of that provision says that the office of the president shall become vacant, A, on the expiration of the period specified in clause 1 of this article, or B, if the incumbent dies or resigns from office or ceases to hold office under Article 69 of this Constitution. My view is that there's no ambiguity as to the terms that a president, an elected president, must, hold. So I will go by this law. I do not think I have anything to say in contravention of this, or I will not prefer any amendment.
We take it that you don't have any issue and you feel that 2 terms is 2 terms and it cannot be reviewed under any circumstance.
I think my position is clear, that the law is clear, so we should maintain it as it is. Thank you.
Thank you very much. My other issue, going by your answer to my second question, that you don't think that we should review the mandate for retirement. From your CV, I see a challenge because I'm really going through your calendar. And if I go through your calendar, I see one thing, that your effectiveness will be just for about 3 months. And yes, if going through the calendar, you go to holidays, vacations, and all that. So I am thinking that if we don't review that law, how can you be? Because you are an institution, and therefore, if we have to, Ghana has to benefit your very existence in the judiciary. It is important that we look at that law again. Thank you.
Thank you, Madam. Thank you, Chair. My position on the review of the age hasn't changed. I will stand still by it. Now, the challenge you are talking about, Mr. Chairman, there are precedents. in the service. Some judges were appointed, and if you permit me, I will mention names. Justice Professor Kuji was appointed to the Supreme Court in August 2003 during the time of President Kufuor, and he retired in April 2004, a period of about 8 months. Justice Afrebu was also nominated from the Court of Appeal to the Supreme Court, also during the time of President Kufuor. He was there for only 1 year. So the president is there. I also think that promotions come from above. So, as a Christian, and if it has pleased the Lord for me to be promoted, even if it is 1 day, I think when I go there, I will do what is expected of me, and I will leave the service honorably. Thank you, Mr. Chair.
Thank you very much. Nanamwa, Utsirwa.
Merci.
Honorable member is now the turn of the ranking member of the committee, Honorable Alexander Afanyumaki.
Chairman, thank you very much. Honorable nominee.
Yes.
Questions that I shall take you through. We'll look at areas such as perceived absence and reluctance of Ghanaian courts, particularly the Supreme Court, to engage in bold, transformative adjudication in matters of public interest, social justice, and constitutional enforcement. In fact, I have drafted these questions to test your judicial philosophy, your understanding of constitutional interpretation, and your views on the proper role of the judiciary in nation building. I wish you well as we proceed.
Thank you.
By the way, I heard you talk about your journey thus far in public life. Just in a very short phrase, say something about what you've learned, especially in very difficult moments, to inspire the youth of Ghana, who, by unfortunate situation of their background, are placed at the lowest ebb of fortune's wheel and feel that there is no life for them at all.
Thank you, Mr. Chair. What I would say in response is that hard work pays. So the youth must be conscious of the fact that in shaping their lives, hard work must be at the center of whatever they have chosen to do, whether career, job, and what have you. And as a person, you must also fashion for yourself. You must plan. You must plan for yourself. My journey started as a recorder. If I have not planned that, I also want to be like, and in fact, I was inspired by both the judges and the lawyers that were.
Enough, my lord. Enough, my lord.
Thank you.
Lord, your records have it that you are a chief, correct?
Certainly, yes.
You are a gazetted chief.
I am.
Since when?
2016.
Where you come from, did you ascend to that throne through maternal inheritance, or it was an honor, or through paternal inheritance?
Maternal.
Maternal, very well. So you've at all times been a royal, correct?
Certainly, yes.
Very well. Do you see the performance of your traditional role conflicting with your judicial function?
Thank you for the question. In fact, both the traditional role and my role in the service are very important and dear to my heart. So I've tried to manage as far as possible to ensure that I give equal attention to the two. Of course.
My lord, it's enough. What I would suggest strongly to you is to have at the back of your mind the rule of brevity. I don't want to keep you for too long, but if you decide to be answering my questions with long answers, then you may stay for long and the impression will be created that the leader of the mighty minority is keeping you for too long. So just bear that in mind. Now, in your career as a judge, have you had the occasion of spotting talent at the bar and taking interest in directly inspiring such talent, including nurturing them to rise in the profession?
Thank you for the question. Indeed, the questioner himself was practicing in my court. I then come from Kumasi, and he has also come out from the law school. Look, the point or the habit I have cultivated over time is that I always want to encourage young practitioners to have confidence in themselves. It's not good that as a judge, if a lawyer came before you, and a junior lawyer for that matter, I mean, we are all prone to mistakes. If a junior defaults, then you'll be shouting on the person. It has put some potential but brilliant lawyers shy away from practice. So I try to, from Kumasi right down to Accra here, and even in second A, you can check. And you are testimony of that. Thank you.
Lord, now let's look at the role of judicial activism in a constitutional democracy. What is your own understanding of the role of judicial activism within Ghana's constitutional framework? And to what extent should judges be willing to creatively interpret the Constitution to address emerging injustices or legislative gaps? The emphasis here is creatively interpret. In fact, I'm not singling out a particular judge for mention, but I've been reading his judgments lately. If you look at my Lord Kulendi's ruling, you can see a certain path, okay? And you realize that he is pursuing certain path, perhaps because of his long years in private practice and from private life to public life, he has a combination of these and is shaping his approach in the law. I have seen your judgments, and I, to some extent, can say that your thinking in the law is towards that pragmatic approach to seeing things. However, quite broadly, I mean, for over 10 years, I have not practiced in your courts, and I have not had the benefit of reading your judgment lately. So I want to know from you, how willing are you to creatively interpret the law? We are aware recently that there's a bold decision that when a process is filed and it is served, although it may be praying for that process, may be praying for an injunction, until that is expressly granted, there cannot be that presumption that you should be stopped. That's bold and very creative. What is your own position?
Lord, before you come into answer, a few minutes ago you've been asked to observe the rules of brevity. I would want to plead with Osahi Togbi to also observe the same rule in asking the questions. Please, you have the floor.
Thank you so much. Mr. Chair, yes, they say I should be brief as much as possible. But some questions will allow you to go into a little details. Now, the case in contention...
I'm not limiting you.
Okay.
So please proceed. I mean, this is a critical matter that you should...
I do not think that that case espoused a general rule that if an injunction application is filed, will not stop a party from doing whatever he is doing. My appreciation of that case and the ratio in that case was that if it is a constitutionally mandated body, then, of course, the law has been that the court can sparingly grant injunction against a constitutionally mandated body. So I believe it was on that basis that this thinking has come. I mean, and the law, is said that it's always evolving. So if the position formally was that you can't grant injunction in any case against a constitution mandated, now they are saying that even if the application is pending, you cannot stop the... that is the position of the law currently. And until the Supreme Court gets the opportunity to depart from that position,
But that was by way of example. So my question to you that, how willing are you to be creative in your interpretation of the Constitution to address emerging injustices or legislative gaps? I mean, I want to know from you how willing you are to be creative in your interpretation of the law. As to the debate regarding your understanding of the ruling, we can use another forum to discuss that.
You see, Tufo and Ateniana has settled the law that our constitution is an organism capable of growth. In fact, in other jurisdictions like Australia, Canada, and the rest, in Australia they say that even the constitution is like a tree. It has to grow. Our constitution is the fundamental law of the land. And it's, apart from being a legal document, it's also a political testament capable of growth. So when the situation arises that you have to interpret the constitution, the provisions of the constitution to meet the exigencies of the time, I'm all for it. I mean, what is the sense of a judge, especially when we are going to the Supreme Court? And no, I'm not a timorous soul. I'm not timorous. I will apply the law as I understand it and interpret the Constitution to suit the exigency of the time. So that is my view on that.
Thank you very much.
My Lord, so let me get this from you. What is your own understanding or your appreciation of judicial activism as a judge?
You know, there's this, they say that judges do not make laws. Of course, that is the general rule. But it's also tried that where there are gaps, it's permissible that the judiciary will grease those gaps to make the law understandable, you know, for everybody to, you know, follow it. Let me give a typical example. You know, if you look at, I think, Article 22, it is provided that Parliament should pass law on the property settlement when the Constitution comes into force within 6 years. 6 months. Parliament has not done that, but it became necessary for a Supreme Court judge to espouse this principle of jurisprudence of in this case of Mensa versus Mensa. You see, you will call it as judicial legislation, but it's not necessary because I do not know. The Parliament has then not passed the law, and the situation demanded that there should be something about the case. That's why jurisprudence of equality principle came in, and it was a judge who, being bold. So if the situation calls for it, and I feel that it is Parliament who must do it and they haven't done it, or the law is such, it's so ambiguous that we need to oil it, put greases in it to make it understandable, readable. Why not? I'll be prepared to do it. Thank you.
Now, my Lord, let's delve a bit into Article 132, the supervisory mandates of our court, of the Supreme Court. 132, yes, please. That deals with quo warranto, mandamus, certiorari, etc., prohibition and all. Now, practice at the Supreme Court, I came across some inconsistencies in terms of the approach to this constitutional provision. And in fact, as a practitioner, anytime I had my case before the Supreme Court, certiorari application, and I saw a particular panel, I could straight away predict that this panel, they would not hear me. And at all times, I was never wrong. Because you could see that if this particular panel is presiding, however meritorious it is, they will say, go on appeal. Why are you coming here? And in fact, the anti-Article 132 bench would always say that supervisory powers in 132 are discretionary. So they would not venture, however meritorious your case may be, because they want you to go through the appeal process because you have appeal as of right. And they will further argue that go through the mill. Whereas you also believe that invoking their supervisory right would lead to justice for the party who is aggrieved. What is your own view about Article 132? Do you hold a position that even where the error on the face of the record are so patent, you must discourage certiorari applications or prohibitions under 132 by telling lawyers or parties to go through the long haul?
Yes, answer the question subject to the fact that some Supreme Court judges are anti-Article 132. So you may proceed to answer the question.
My Lord, hold on a second. Chairman, with the greatest respect, I don't want us to repeat what happened yesterday. If you have a certain appreciation of my question, you can take it with me privately. But this interjection as if subject to what I meant. If you go to court, I don't know about your practice at the Supreme Court, but I am an active Supreme Court practitioner, and all the judges know. If you go to the court, you know this is a pro-state bench. This is a pro-this. We know, those of us who are very active, we know how they think. If the matter is on a certain direction, how they think. There are some judges that when you go with a sexual application, they will encourage you to go on appeal. So don't come in by saying that subject to it is not derogatory. What I meant by bringing that one in was not to denigrate anybody. So please, let it flow. Then we can make progress.
Well, I do not want our record to show that some Supreme Court judges are classified to be anti-32.
It is not. Maybe you don't understand it. It is not derogatory.
Please proceed to answer the question, man. Was that?
Thank you, Mr. Chairman. Mr. Chairman, are you listening?
Please proceed to answer the question, man. Was that?
Yesterday we were calm. If you want to discharge, I'll stop. He should discharge him, let him go and have his way. History will record. And one day, they would also be in opposition and this thing will play to them. What is this?
Please, you have the floor. Proceed to answer the question, minus that.
Thank you, Mr. Chairman. I do not know those judges the chairman is talking about, that they are anti-Article 132. But you see, I think the practitioners should also be respect. Because it appears to me that it has become fashionable that cases that are tried in the High Court or in the Court of Appeal, the least opportunity, the lawyers who want to go to the Supreme Court by way of certiorari and, the prerogative, with prerogative applications. Because they feel that that is shorter than, going through the appeal process. But Mr. Chairman, see, there's this principle that the Superior Court, there's no case is above that of, so it has always been cautiously maintained that before you touch the decision of a Superior Court, by judicial review, you need to be cautious. So the best option, to me, I think that is what the anti-182 provision chairman is talking about. Because they will take the position that once a Superior Court is a court of unlimited jurisdiction, they have, it's presumed that the judges on that bench are presumed to know their law. Of course, as human beings, they are also prone to make mistakes. But if the matter is for an appeal, I think it will be better served if you go to appeal. Because when you go on appeal, you see, the Supreme Court, they will have the opportunity to write judgment based on the merits of the case. One is about certiorari. Certiorari, we are not talking about the merits of the case, but about procedural rules. For example, if it is established that the error was patent on the record that said that it was utter varies the powers of the court, that one is acceptable. Or if they didn't have the power at all. But if they had the power and they did the mistake in the exercise of that jurisdiction, the best option or the better option is to appeal. So my position is that 182, yes, but
Hello, would you be the type who would hasten slowly in dealing with matters of certiorari, or you look at it case by case?
I will look at it on a case-by-case basis.
Very well. Let's make progress. Now, let me take you through constitutional mandates and judicial restraints. Our country's constitution grants broad interpretative authority to the judiciary under Article 2 and Article 130. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways?
Can you repeat the question again?
So, I'm saying that Article 2 and 130.
Yes.
In your view, these provisions clothe you with those interpretative powers. In your view, what factors have contributed to the judiciary's cautious approach in exercising this power in transformative or activist ways? Now, I would give you one case.
Okay.
The Parliamentary versus the Kojoka Adra versus Attorney General matter. My Lord Acting CJ wrote the judgment for the panel, and I will just explain to you. This had to do with public servant participating in our partisan political activities, and the contention of the plaintiff was to the effect that, yes, the 93-1, hold on a second. because students are listening to us, I don't want to make a mistake. 91 to be, yes, it's here. 94, 3B, those prohibitions. Now, the contention of Mr. Agra in that matter, which had to do with the eligibility and the prohibition, who qualifies to be a member of parliament. So his case was anchored on 94 3B, which says that, let me read it in full. A person shall not be eligible to be a member of parliament if A, is prohibited from standing election by law in force in Ghana by reason of his holding or acting in office, the functions of which involve responsibility for or are connected with the conduct of an election, or responsibility for the compilation or revision of an electoral register. B, is a member of the police service, the prison service, the armed forces, judicial service, the legal service, the civil service, the audit service, parliamentary service, the statistical service, the fire service, customs, excise and preventive service, the immigration service, or the internal revenue service, or is a chief. Now, in this matter, Mr. Kojogadre's contention was to the fact that yes, these have been listed, but there were officers in the public service, specifically Ghana Highway Authority and Ghana Education Service. And he does not understand why, if somebody is a member, a staff of Ministry of Education, the person is prohibited. Ministry of Health, the person is prohibited. Ministry of Roads and Highways, the person is prohibited. But if the person is a staff of Ghana Highway Authority, the person will say that I have not been listed. Now, my Lord Bafuboni took that conservative stand to say that to the extent that those others have not been listed here, it means that the Constitution did not contemplate them to be part. I disagree with him, but I yielded. I've not seen anybody going back to really further tease the mind of the Supreme Court on this. So it still remains a law, and subsequently, those who are in the public service mainstream but not listed here are part of our partisan political activities. So my question to you with this background is, to what extent would you say that the cautious approach in exercising this power has affected